Fourth case on this morning's docket, case number 120875 in the matter of Kevin Shepard.
Good morning, Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I request 2 minutes rebuttal.
2 minutes is granted.
Thank you. This is an original action in discipline. It's arising from 2 complaints. Mr. Shepard, the respondent in this case, stipulated to both the facts underlying the complaints as well as the rule violations. He did not file any exceptions to the hearing panel report, so really the main focus of today's argument is going to be on the recommendation of an appropriate sanction. But before getting to do that, I would like to give a brief sort of factual summary of the complaints and the rule violations to provide some context for my recommendation of the sanction today. The first complaint arose from Mr. Shepard failing to file a brief, and his client's appeal was consequently dismissed. This misconduct was compounded when the matter was docketed for investigation and Mr. Shepard told the investigator that his client no longer wanted to pursue the appeal, and that statement was not in fact true. Once confronted, Mr. Shepard acknowledged that his client was not aware that the appeal had been dismissed. Mr. Shepard consequently advised the client that the appeal had been dismissed. Mr. Shepard paid for the client to get appellate counsel who was able to get the appeal reinstated, and the matter was heard. The rules that he stipulated that he violated in this case were 1.1 competence, 1.3 diligence, 1.4 communication, 1.16 failure to withdraw from representation, 8.1 which was his basically misleading the investigator in the disciplinary investigation, 8.4C which is conduct involving dishonesty, and 8.4D conduct prejudicial to the administration of justice. The second complaint arose after Mr. Shepard submitted 5 checks on behalf of clients for diversion fees in district court. These checks were returned for insufficient funds. When the prosecutor asked Mr. Shepard about this matter, he said, well, it was a mix-up because he had changed banks. That statement was not true as well. Consequently, when this complaint was docketed, we did an audit on Mr. Shepard's accounts, which revealed numerous problems. Just quite frankly, they were in a big mess. And the violations that he stipulated to that are 1.15 and 8.4C. At the hearing, I requested indefinite suspension. Mr. Shepard requested censure and probation. The panel recommended a 2-year suspension, but said that he should be allowed to apply for reinstatement after 1 year and go on probation. I'm going to turn my discussion now to what I'm here to recommend today. I have found in the course of doing this job that a lot of times the recommendation for sanction is probably the most difficult part of the job. At the time of the panel hearing, I didn't think it was a difficult task because of 2 things. 2 really aggravating factors, and one was Mr. Shepard's prior discipline. In 2009, as this court knows, he was suspended for 1 year. He was allowed to, after 1 year, I think he was suspended for 2 years, but after 1 year, he was allowed to apply for reinstatement and be placed on probation for 2 years. He did apply for reinstatement. He was placed on probation. He successfully completed that probation. This prior discipline in 2009 is similar to some of the misconduct in this case, and that involved the trust accounting, so it was a 1.15 violation, and it also involved dishonesty in his own bankruptcy proceedings. And then the second really kind of aggravating factor in this particular case is this issue of dishonesty when he made these misrepresentations to the investigator and to the DA's office. This case has become more difficult because the amount of time that's passed. And as this court is well aware, we have evidence in aggravation and mitigation that's presented at the panel hearing, and Mr. Shepard presented some pretty significant mitigating evidence at the panel hearing. In the time period that's passed in the last 10 months, that mitigation evidence has only gotten stronger. And so our cases are a little unusual. I want to go over this mitigation evidence, that some of it was presented at the hearing, some of it has occurred after the hearing. I have Some of it is contained in the affidavit that was filed with this court, but I have personally confirmed this evidence. I've spoken to opposing counsel, and he has no objection to me talking about this additional mitigation evidence. So with the court's permission, I'd like to go ahead and talk about the mitigation evidence. The first deals with recovery efforts. And this is important because there's a lot of things that have taken place in Mr. Shepard's life that had not happened in 2009. The first is his recovery efforts from some pretty severe traumatic and abusive childhood events, and that stems from a relationship with his father. I took a look at the transcript from the 2009 panel hearing, and that issue was never addressed, and clearly it was something that Mr. Shepard was dealing with then. His father ended up dying in 2010, about a year after the prior disciplinary hearing. I think the failure to deal with that issue certainly aggravated his addiction issues, which we'll talk to. His therapist testified to that issue at the panel hearing this past year in 2018. The therapist said that really this is what has turned a corner in Mr. Shepard's life, his ability to start addressing some very traumatic things that happened to him as a child and to start healing from that. Mr. Shepard, as he stated in his affidavit, continues to meet with his therapist twice a month to continue to deal with these issues. I think this is important for the court to consider because it might be a key to why things could be different this time around than they were in 2009. The second is his addiction recovery. After a prolonged period of abstinence from alcohol and drugs, which included the time period in 2009, the prior disciplinary proceedings, Mr. Shepard resumed drinking in about 2013. After he's released from probation, he also was using drugs. And we've already talked about maybe the other abuse issues sort of contributed to that. In November 2017, he ceased using alcohol and all drugs, including Adderall. At that time, he quit going to casinos and using bookies. However, it wasn't until November 2018, the day after our second hearing in this matter, he stopped all forms of gambling. So Mr. Shepard has some serious addiction issues that he has acknowledged. And the way that he is dealing with those are trifold, really. First, he became involved with KLAP, which is new from 2009. He signed a KLAP monitoring agreement. He has a KLAP sponsor. He and Bryn Rose from KLAP and the KLAP sponsor meet at least once a month in person, oftentimes more than that. Bryn Rose represented to me that they speak often on the phone and that they have he's closely working with KLAP. He also stated in his affidavit to the court that he attends weekly AA meetings. And then after the April 2018 hearing, the hearing took place on 2 days in the present disciplinary matter. He began meeting with Brian Smith, and they have, for the last year and a half, have been working on the 12-step recovery program. Brian has represented to me that their meetings vary from weekly to monthly and with frequent phone calls in between. And I'm sure Mr. Shepard will testify to you today that recovery probably is his number one priority. So I think that's a significant mitigating factor. The third issue is his recovery from what I like to call his law management practice issues. Before the first hearing, Terry Beck, who is his former probation monitor, began meeting with him again and acting as his probation monitor. Terry Beck and Mr. Shepard meet bi-weekly. Mr. Shepard, and he might have to clarify this, either has one full-time assistant right now or two part-time assistants, the equivalent of having one full-time assistant. At the time of the first hearing, he kind of had some sporadic help with legal assistance that kind of contributed to a lot of the problems he had. He has also hired an accountant to get his trust account and his operating account in order. He has participated in meetings with our office. I personally met with Mr. Shepard, his attorney, Mr. Shepard, his attorney, his accountant. We performed another audit of his accounts, and our auditor said these are some things you need to tighten up. I had a meeting with them afterwards. They've done that. And then also I suggested Mr. Shepard meet with Danielle Hall in our office, who works on law management practice issues, and he has met with her, voluntarily done some self-assessments about his law practice issues, and he is working with her to find ways to improve it. So he's putting in the work on that. And then the last thing I want to talk about is just really Mr. Shepard's practice, and I think this is important for the court to consider as well. First of all, at his hearing, Judge Anderson here in Shawnee County Court testified to what a great job that Mr. Shepard does for his clients. I contacted the administrative judge at Shawnee County because I kind of wanted to get her feedback on this as well. And she told me I could share this information with you. She reported that Mr. Shepard is one of 10 attorneys in Shawnee County that is qualified to do high-level felony cases, and he's one of the most respected attorneys on that list. She said that his ability and presence to handle these cases would be sorely missed if he's suspended. More importantly, Mr. Shepard was recently appointed by Judge Rios to handle a pretty high-profile murder case. He went to her when he was appointed and said, hey, my license might be suspended here pretty soon. And she told him, I have no qualms about you handling this case as long as there's no restrictions now. I followed up with her. She said that he is a competent, excellent advocate, a strong trial attorney who can handle major cases. She hoped that this case could be resolved in a manner that allows him to continue to practice. So, after having said that, where does this leave us today? You know, I understand that the purpose of lawyer disciplines is to protect the public and the administration of justice from lawyers who have not discharged, will not discharge, or are unlikely properly to discharge their professional duties to clients, the public, the legal system, and the legal profession. I understand that the main priority, our mission of my office, is to make sure that the public is protected. So is there a way to protect the public when dealing with an attorney, one, who did not appear to learn from his prior discipline, and two, engaged in dishonest conduct? About a year ago, I would have told you no, absent an indefinite suspension. Today, I'm saying I hope so. So my recommendation today is that I stand on the indefinite suspension. I ask that that indefinite suspension be stayed, and that Mr. Shepard be placed on a 5-year probation plan. I have no issues with the proposed probation plan he has submitted, except I would, of course, defer to any added conditions this court would think were appropriate, and I would suggest the added condition of having a monthly review of Mr. Shepard's trust account, his operating account, and his personal account to make sure that he continues to abstain from all gambling activities.
Does that conclude your presentation?
I'm sorry, that does conclude my presentation.
Do we have any questions for counsel? Thank you, counsel.
Just a clarification. So I can't remember if abstention from gambling is a condition of probation, but you would add it if it is not.
Well, that's a great question, Justice Lugert. If you look at the hearing panel report, they had some recommendations for while he's suspended, and that included cessation from all gambling. And absolutely, I think that should be a condition of the probation, as well as alcohol, drugs, as well. Yes.
So basically also look at the hearing panel's recommendations.
Yes.
I'm sorry, what was your statement?
That we should also look at the hearing panel's recommendations.
And those recommendations, a lot of them were the
Which talks about a psychological evaluation?
Right. I'm not sure if that's necessary, because I think Mr. Shepard, at least in my conversations with him, has admitted, yeah, he has a gambling problem. So I don't think there's that he necessarily needs that diagnosis at this time if he's willing to admit it. But I would certainly don't think there's anything wrong with having another evaluation on top of it.
Very well. Thank you.
And can I just say one more thing? I think part of why the hearing panel discussed this was at the November 2018 hearing. Mr. Shepard was asked, are you still gambling? And he said, well, I'm still doing the, I don't even know what it's called. It's like an online where you can bet on games and stuff. And I think, Mr. Shepard can talk about that, but I think their concerns were maybe you don't get it, that that's still gambling.
Thank you.
Mr. Chief Justice, your honors, may it please the court. John Ambrosio on behalf of the respondent. I concur with my colleagues' recommendations. We have no problem with the 5-year recommendation as far as his probation. We have no problem with any additions to the probation plan, which I've agreed with my colleague we would reduce to writing in the next couple of days and change the probation plan. I've advised Mr. Beck, who is supervisor of these possible changes. He is aware of them. The only problem we're going to have, if the court sees fit to place him on probation, Mr. Beck probably will retire in the next 2 or 3 years, so we'll have to get somebody else to act in his stead, and I'm sure we'll be able to find somebody. As long as I've been doing disciplinary work, which has been about 9 or 10 years, Mr. Shepard's transformation has been absolutely phenomenal. I can only think of a couple of other cases where I would be able to say that to the court. When he first was disciplined and you suspended him 10 years ago, he was an angry man. He was angry at the court. He was angry at the disciplinary administrator's office. He was angry at me. He was angry at everybody. He hated everybody. He couldn't stand what had happened to him. And then 2 years ago, on the Friday after Thanksgiving, it's like a light went off. He had started working through the abuse, which none of us could understand since none of us had this visited on us. He had started working on that abuse. But 2 years ago, on the day after Thanksgiving, he decided, I'm not drinking anymore. I'm not using any drugs anymore, and I'm going to work my program. And that has been going on the day after Thanksgiving for 2 years. He has been working his program. He's meeting with his therapist in Lawrence weekly, sometimes twice a month, depending on their schedules. He's dealing with those abuse issues, which I won't even go into now because some of these things need to be kept to ourselves. But I just ask you to just think about the worst possible abuse being visited on someone. It was visited on my client. The alcohol and the drugs killed him, killed his practice, killed his representation of his clients, but he is dealing with those on a daily basis. He works with Bryn at KLAP. He has a KLAP monitor. He meets with that monitor as often as necessary, at least once or twice a month. He's worked with Brian Smith, who is recovered and been in recovery for quite some time, and Brian and Bryn are here to give him support as his newfound girlfriend. They've been together for a number of years, and other people who really think he can make a difference in this legal community. He has done everything that this disciplinary office has asked for him. Ms. Moylan, to her credit, and Mr. Hazlitt and the rest of his attorneys have gone out of their way to help save Kevin, which Kevin is grateful for. He now, instead of hating them, thanks them and realizes that they were there to help him in the first place, but he was not ready. He had not fallen far enough. He fell far enough, and now he is in recovery. His affidavit was prepared by my client. Normally, I cut, I paste, I have to write the affidavit. My colleague called me and said, was that affidavit written by you or was it written by Kevin? That affidavit was written by Kevin. It came from the heart. I think I changed 2 minor grammatical errors because they made me crazy. But everything in there talks about what he is doing to help himself. And the important thing is, we need him in the criminal law committee. We don't have enough people who do the high-end homicide cases, who can do the high-end criminal cases. We've had some deaths and we've lost some good people. We've had those of us who used to do it, who are too old to be doing it on a daily basis. We have the public defender, and then we have people like Kevin. I think probably Judge Wilson is wrong. There are less than 10 people who really handle those type of cases. He checks the law, he reads the law, he researches, he goes to the jail, he visits with his clients, he holds their hand and represents them to his best ability and does a great job. We need him for that, but we need him only if he continues to work his program. If he gambles, and I believe when you're addicted, you can't just pick and choose what addictions you can go along with. If you drink and you use drugs, then it's an easy step to turn to gambling. And Kevin turned to gambling. He loved gambling. But when Mr. Rankin, who was on the panel, said to him, don't you think you need to stop the gambling? When we left the hearing, Kevin said to me, I'm going to stop the gambling too. I guess he called me the next day. It wasn't the same day. And he stopped. And he's out of it. He's not online gambling. He doesn't go to the country club and gamble. He doesn't have a bookie. He's straightened that out. He now understands his addiction. And day to day, he doesn't drink. Day to day, he doesn't use. Day to day, he doesn't gamble. And he only takes it that one day at a time. He has done a tremendous job in working his program. And I know what you're saying, but Ambrosio, you came up here 10 years ago. We put him on probation. But he had not dealt with the abuse. He had not really dealt with what led him to the alcohol, what led him to the drugs, what led him to this destructive, awful behavior. He's lucky he's not dead. If these disciplinary cases had not been filed against him, if the DA had not turned him in for his violations, I'm not sure he would be here the 2 years after those violations. All I'm asking is that you give us a chance to continue to work with him, to allow us to watch his behavior, give him the tools to work in his own addiction, and give us the tools to be able to protect the public. Now, with your permission, my client would like to address you. That's your pleasure? Kevin? Mr. Shepard, I'm not supposed to call you Kevin. Go ahead.
It please the court. I struggled for quite some time about what I was going to say here. I've been thinking about it for a long time. And I wrestled over trying to say the right thing. And then I let go. I'm not worried about saying the right words. I'm going to tell you what I'd like you to know about me. The things that might not show up in the record before you. The transcripts and the recommendations. This is the last stop in these proceedings, and I want to keep it simple. First, I'm not proud of why I'm here. It was a string of reckless behavior. It was selfish and dishonest. And I put my clients' faith and their cases in jeopardy. And it hurts facing the truth. And I think that's really cost me the first time I was here. I never came to terms with why I was suspended. And the reasons for my suspension then, and the reason why I'm here today, are because of me. And not because of my addictions, not because of the concussions, not even my father. It's me. I'm the reason I'm here. So we go to the proposed probation plan. And it wasn't designed to save my law license. It was designed to save my life. Back when we put it into effect, in November of 2017, let's face it, if I was here in November of 2017, I'd have nothing to talk about. I'd be for sure suspended, and probably forever. But after all the crap I pulled, and as a repeat offender, I wasn't even thinking about being placed on probation back then. I was just trying to see if I could salvage something before this suspension would go into effect. I was in a real dark place. I wanted to die, but I didn't want to quit. I didn't want to quit. And for the grace of God, I put everything I had into my recovery. I don't know why. I really don't. I mean, something up there was, they were really helping me out up there. Because I've seen some people that they struggle with what I'm struggling with. They don't make it. And I've been blessed. So my probation plan was really my recovery plan. And the written plan doesn't cover everything. I mean, there's more to it. There's a lot more that was said, and there's a lot more that goes into my recovery. And I work it every day. But the probation plan has made, it's made my recovery something of substance. Something I don't ever want to lose. It means a lot to me, my recovery. Whether I'm suspended or not, it's something I've never had before. I was, before I've had brief periods where I've been able to keep it together and, stay clean for a little bit and, clean up my behaviors, just clean myself up a little bit. But this time, this time it's really actually hitting the the root of the problem. That's me, and that's what I'm working on. And if the court does rule in favor of suspension, the efforts have not been wasted. I've come further than I've ever imagined. I finally have something to offer and be of service, whether it's in the legal field or not. As I said, I got to the root of my issues and addressed the real problem. I also like you to know I have a lot of passion for what I do as a lawyer. It's been one hell of a ride here. I've had a lot of great experiences and have had the fortune of helping clients go through some really big messes. Yesterday was an all-day preliminary hearing. It was long. It was exhausting. A lot of different charges, murder, attempted murder, a couple different robberies. Lasted all day. I mean, we took a 45-minute break for lunch and went all the way to 5:30. I was exhausted. I didn't know what to think at the end. But there was another trial going on down the hall in the courthouse. It's a new lawyer. And I've seen him run around here for the last year. It was his first jury trial. And he got his client in acquittal. Heard the words "not guilty." And I thought, man, I remember that. And I remember my first trial, and I remember the last one I did. And it's been this job, yeah, it can pound the life out of you, but it has its rewards. And I'm really proud of my accomplishments, and I'm proud of what I've done. I'm proud of those times when I've been on the right side of emotions to suppress and been able to walk my clients through, and I'm proud of what I did to get here. Passing through law school, passing the bar. I was a research attorney here when I was passing the bar. I remember when I passed the bar, I ran through the hallways here yelling, "Who let the dogs out?" Hoo, hoo, hoo. It was a popular song back then. But I was so excited, and I don't ever want to forget how special it is to be a lawyer. It's really a blessing to be, part of this field. And I was very fortunate to be here, and I'm sure that if suspension is the right call, I'll be leaving at the top of my game. I never thought my practice would be this good. I never thought recovery would go this well. I mean, it's going really good right now. Things are great, and I'm sure this journey will carry over to whatever I do next on the horizon. Whatever's next on the horizon, it's going to carry over, even if I'm suspended. This effort has not been wasted. Now, if the court blesses me with probation, I'll aim even higher, because I'm not done. I'm not tired. I got more in me. I feel stressed. I feel burned out at times. As I said, this job can really pound the life out of you. But I've got more energy than I've ever had. Now, speaking of blessings, the last thing I want you to know is how grateful I am for the time I've been given to recover. Penny Moylan said at my second disciplinary hearing, time is on my side. Well, it wouldn't have been if it wasn't for the disciplinary office, KLAP, and all the other people and the resources that opened doors for me to walk through, crawl through at first. I tried to mention all the people in my affidavit that were instrumental in my recovery, and believe me, I know recovery doesn't have a finish line. Not for me, it doesn't. I'm very fortunate no matter what happens. And I'll answer any questions this court has.
I had a very brief question. Several allusions have been made to your criminal trial practice, and in particular, what I would regard as a high-profile case that you're deeply involved in yesterday.
Right.
A lot at stake there.
Correct.
My question to you is, if we were to allow you to be on probation, what assurance can you give us that for clients like that, that you'll be doing the best you can and we're not going to have a backslide? Because you know what the consequences for that individual would be.
Right. Yeah, my dedication and my zeal is at the highest at this point. And as long as I keep doing what I'm doing, it's going to be it's going to continue. What happened was, as my counsel said, and as I think Penny Moylan had addressed, I finally got to that issue, and I hit that dark spot, that one that was holding me back. And I feel like I've really made a breakthrough, and that's the assurance I can give you, is that I'm moving forward. I think that before, I always knew. I would look in the mirror. I'd say, yeah, you know, people have said you're doing a great job. You're doing a great job, but deep down, I felt like a piece of crap. Deep down, I couldn't look at myself, and I can today. And you know, Oz never did give nothing to the Tin Men. They didn't already have.
Very well. Thank you.
And I think what he's saying, and I know our time is up, is he can tell you today he won't backslide. Because if he had said, I'll tell you I will never backslide, that would mean he's not working his program. All he can say is, Mr. Chief Justice, members of the court, today I won't backslide. Tomorrow is another day. I think that's the AA credo. I'm not in that, I'm not involved in that, but I've read enough to know, and I think that's what he's trying to say, and I didn't mean to go on.
That's probably true. I mean, it is a day at a time, and you know, we don't know what tomorrow holds, but I feel pretty confident today. And I think my client, and all my clients, I've got several of them, and I think they're all in good hands.
Very well. Thank you.
Thank you, sir.
You reserve 2 minutes.
I just wanted to make a point of clarification, maybe illumination too, because this court might not be used to looking at KLAP monitoring agreements. But if you look at Mr. Shepard's probation plan, in there's a specific, because a lot of it deals with law practice management issues. And the difference between what happened then versus now is that the recovery component is part of this. And so paragraph 25 says, respondent shall follow the voluntary monitoring agreement entered into with KLAP. And KLAP has the specific things like no alcohol, no drugs, weekly AA meetings. So I want you to know that recovery is part of that probation plan. It's just encompassed within the KLAP monitoring agreement. But with that, I don't have any further presentation unless the court has some questions.
Any more questions? All right. Thank you, counsel. We thank all counsel for your comments this morning and now this afternoon. The court will take this matter under advisement.